Yes! Hello, my beautiful friends. What an amazing day it is, and welcome back. I hope that your weekend was absolutely outstanding and you're ready to dig into some Supreme Court business, provided the words work today, because we've got a lot of business to attend to. Very glad that you're back. We got a little bit of a preview on what's coming up before we zoom into further review. We're going to go through the Ninth Circuit up to the Supreme Court because we got three kind of things that we're covering today. One, this filing was an order from the circuit, the Ninth Circuit Court of Appeals, rather, that Trump is now taking up to the Supreme Court of the United States. And this case involves the AFL-CIO. This is the Supreme Court filing that just came out fresh out of the oven into the Supreme Court today from D. John Sauer, the Solicitor General of the United States of America. So we're going to go through what he is asking the Supreme Court to do, which is to allow Trump to continue the firings. Okay, all the unions came out and said, don't fire anybody. Let all these bureaucrats live on indefinitely for all time. And the lower level judges said basically, yeah, sorry, Trump, you're not the president. I don't know who you think you are, but we're the president because we're the judges in robes. And now Trump has taken this up to SCOTUS, so we'll go through that. It's a nice filing from D. John Sauer. We'll peek in what's inside because this is a big one. This is like most of the executive branch that we're talking about, so we'll go through it. We also then will talk about what happened in the Supreme Court today because they dropped this big list of orders and there's some good stuff inside and some not so good stuff inside. So we'll start with the good news. We got this case was accepted, an elections case talking about how ballots need to be in and counted on election day in Chicago, Illinois, I guess, or somewhere in Illinois. They were changing the rules and they would allow the ballots to come in, not joking, 2 weeks after the election. So Judicial Watch and a bunch of people sued way back in 2022. And now the Supreme Court has just accepted this case. And so we'll take a look at what the Supreme Court said about it and then review what this case is all about because they just submitted this application. Now the Supreme Court will hear it. So we'll go through the question, of course, do we have election days or do we have election, kind of open seasons while the Democrats can just rally as many people as possible to close the gap on whatever the margin is? We'll come back to that. So all that coming up. Then a disappointing outcome from the Supreme Court on the Second Amendment. And they are now declining to hear this case about so-called assault weapons and assault rifles, which were banned out of Maryland, semi-automatic rifles, AR-15, AK-47s, said, nope, can't have those because they're weapons of war, or whatever the weirdos in Massachusetts are saying about this. So we'll go through it because the Supreme Court is not going to be hearing that case, which means the ban stays. Pretty ridiculous. And we'll go through it because Judge Kavanaugh is kind of like, well, we're going to get to it. I know this is disappointing for you Second Amendment people, but we'll get to it, okay? So just cool your jets, calm your horses, and we'll come back and get to it at a later date. But we've got a bunch of good stuff there. Gun Owners of America responding. And so a great stream planned ahead, my friends, and I'm glad that you're here and with us. And I hope your week is unfolding beautifully. I want to thank everybody who joined us at the Eric's House event this weekend. We had an amazing experience, I would say. We did a virtual tour over at ericshouse.org. We had a couple people send some donos, a couple more than a couple, but we had a handful of people send in some donos. Very grateful for those. Thank you to those of you who donated, but thank you really to those of you who came and participated, shared your stories, and got to get involved in some hope and healing courtesy of Eric's House. It was great. And I really just want to thank everybody for supporting the work there and Mama G. All right. So we've got business to attend to today and let's get to it. Starting with the Supreme Court application. Trump goes to the Supreme Court of the United States and he's now demanding that he can, do his job because they have been pretty quiet on a lot of key issues that we would like them to resolve so Trump can become and effectuate the role of the presidency. But we're now in the Supreme Court, and this is a lawsuit that was brought by the AFL-CIO, the unions suing the federal government. Trump came in, said all these contracts are canceled. you're not getting any more money. And the union sued, basically saying that if you're a federal employee and you have a union, the union, once you get fired as a federal employee, the union will suffer, right? If their union bureaucrats are fired from the federal government, then they can't skim off the top of their dues. So they sued and they're like, hey, wait a minute. We need those bureaucrats to continue working because we need to collect money from them and they're getting paid from you. So what do you think's going on here? So AFL-CIO sued, and we were battling this puppy out until we got to the Ninth Circuit Court of Appeals. And I just wanted to refresh your memory on sort of the thesis behind these union people who were suing. In the conclusion of the opinion from the Ninth Circuit, that was the dissent, they conclude that it's going to be very difficult for the unions to survive. They say there's been a bunch of declarations and there's a startling transformation that's happening because of Trump and what they're doing. There are hundreds of thousands of employees that are facing job loss, federal agency employees. And we're all sitting here going, yeah, we know. Yes, that's the point. Now, because that's upsetting to you doesn't mean you have the right to change that political decision and change that judgment. If you want to do that, you should run for president. But what they do is they say that is economic loss. Okay, that is injury. That is irreparable harm. That the government can't make any changes because somebody who's downstream of this entire thing might be harmed at some point in time. It's this Ninth Circuit saying this, which is wild because just apply this to COVID. Okay, when they said just close your business down for 2 weeks. 4 weeks. 2 months. 6 months. 9 months. Take this jab or else you're going to kill everyone. And winter of remember that? Remember? And everybody's suing, saying, you can't do this. It's irreparable damage to my entire livelihood. They said, shut your mouths, peasant American citizens. And you just go put this into your body or else you're going to lose everything. And in fact, we're going to take away your medical care if you don't do it, said some of them. Okay, lunatics. So now, if it is a duly elected administration who comes in and changes policies, not with the entire American public, not like lock your business down or the Scottsdale Police Department are going to show up at your door because you have people working out in the gym. That's not that. Okay, this is not this. This is Trump running the executive branch, firing people who work in the executive branch. And the unions who don't work in the executive branch are saying we're being harmed by this dramatically. Now, aside from the obvious economic harm of loss in salary, others are going to be forced to relocate and go get new homes. Yeah. Now, their declarations also show a very substantial downstream impact of these large-scale reductions, reaching far beyond the walls of the executive agencies. Pulling a small handful of examples from the record, we point out that the current executive reorganization facilitates the proliferation. All these are the parade of horribles. We got it. If Trump fires these people, you know what's going to happen? We're all going to die. Proliferation of foodborne diseases is going to ravage all of us. It's going to contribute to hazardous environmental conditions. Yeah. Hinder efforts to monitor and prevent infectious disease. Oh, yeah, they're good at that. They did a great job on that last time. And eviscerates disaster loan services for local businesses. Yeah. Which the federal government has been the disaster when it comes to local businesses and to other disasters, and drastically reduces the provision of healthcare and other services to our nation's veterans, which is you always want to tuck the veterans in there. No matter what you're doing, just tuck them in there because you can't object to we're going to kill veterans. We make fun of like the AIDS doctors in Africa who are like doing the AIDS vaccine coalition and no one knows what they do. You go to their websites, like whatever it is. So they do that. They do that the opposite. Like, well, veterans, like you're not going to say anything about the veterans. Like, of course not. We want the veterans to have all the services in the world. We don't want them to go to veteran services who don't provide veteran services, right? Just like the AIDS vaccine coalition, not curing AIDS anywhere. All right. So we get the point. Now, defendants' only response is they're saying Trump, this is the Court of Appeals, his only response is that they can just get back pay. Okay. If they're right and we're wrong, they can sue for wrongful termination like anybody else in the whole world can, right? You get fired from your job, isn't it? You just sue And a judge says, no, you can't fire him forever. Why? Because someone else who's close to you is going to be upset that you lost your job. So they can sue for you to get your job back so that they can skim off your salary. What kind of bizarro land is this? And why are federal employees unionized? The record indicates that what the defendants have sought to do is anything in the ordinary course, and back pay is inadequate because they're going to have to move. And back pay does not reinstate entire agencies' offices and functions. Yes, you have to leave your bureaucratic hellhole. Go find someplace else. It cannot account for harms resulting from loss of income in the interim or for gaps, and it does nothing to address the breadth and the severity of harm alleged by the dozens of non-federal employee plaintiffs in this case, okay? So non-federal employees, it's not even the people who are being fired. It's the people who are downstream of the people who got fired. So that's what the Ninth Circuit came out and said. And Trump said, all right, enough of this, ridiculous. Supreme Court, will you please do something about this? D. John Sauer, Solicitor General for the Trump administration, says this to the Supreme Court of the United States. They say, listen, basically, Supreme Court, the entire federal government is bound into this lawsuit because of these lower level judges who are maniacs. Look at everybody on this list. Chris Wright, Energy, Lutnick, Kristi Noem, everybody, Pam Bondi, everybody that you've ever heard of is on this list. Okay, they're suing everybody. Now, the respondents are the unions, the AFL-CIO and the rest of them, sending in this lawsuit in conjunction with other states and counties and a bunch of other people. A bunch of other cases are percolating along the same line. And so here is what D. John Sauer writes to the Supreme Court of the United States, explaining. All right, Supreme Court. The lower level district court entered a nationwide injunction, nationwide injunction that covers nearly the entire executive branch, 19 agencies, including 11 cabinet departments, from implementing an executive order that directs agencies to prepare for lawful reductions in size. Okay, it's like the whole executive branch. Now, that injunction, which stops Trump from doing what he needs to do to fire these people or to even prepare to downsize, it rests on the indefensible premise that the president needs explicit statutory authorization from Congress to do his job. So he's got core Article 2 powers, but they say that he needs permission from Congress to use those. And that they can superintend the internal personnel decisions of the executive branch, which is a strange thing to think about because we have the separation of powers, which everybody learned about in social studies and civics class. But under our Constitution, the executive power, all of it, is vested in a president who must take care, also in the Constitution, that the laws be faithfully executed. Quoting the Constitution, Article 2, Section 1, Clause 1. Take care that they're faithfully executed. And cares capitalized, as we always point out. What does that mean exactly? Controlling the personnel of the federal agencies lies at the heartland of this authority. The Constitution does not erect a presumption against presidential control of his branch. And the president doesn't need special permission from Congress to actually exercise his core Article 2 powers. In other words, the default is the president can do his job. You don't have to come out and say the president has to prove why he needs to do his job. He can't act unless he overcomes some burden. No. He can do his job. He's going to do his job. And if you think it's unconstitutional, then you can sue or you can get a nationwide injunction, which is exactly what they're doing. Now, what should ordinarily happen is the lower level district courts would just say, you're suing the executive branch for firing people in the executive branch. Okay, who are you? You're a union? Do you have any guaranteed right to be invested indefinitely with the government or something? No, you don't. So then they flip it, right? They invert it. They shift the burden. This happens all the time in criminal law. In other words, when you are charged with a crime, you have the presumption of innocence. You don't have to prove a damn thing. You can sit there and show no evidence whatsoever. And they've got to prove that you're guilty beyond that reasonable doubt. The burden is on them to do it. Now, the prosecution will often come and they'll try to burden shift, and the defendant will be like having to prove their innocence in some way in front of the jurors or something, right? And you file whatever. It's an issue where it's called burden shifting in the law. The other side, you kind of make it their burden to prove that they're innocent. That's not our standard. Same thing here. Trump has the presumption that he can do the job. You don't get to just suddenly reverse that and say, no, he has to prove that he can. The district court's injunction violates these bedrock principles, as well as other established doctrines. Now, as Judge Callahan explained below, who dissented, applicants have shown a likelihood of success and irreparable harm because some maniac judge issued a sweeping preliminary injunction that strips the executive branch of control over its own personnel. Judges in charge. And the unions. Now, the unions improperly bypassed the comprehensive administrative scheme that Congress has enacted to handle federal sector labor and employment disputes. There's a whole separate provision and other agencies that deal with this stuff. You got fired, you're unhappy about it, you're a federal bureaucrat. Go use these provisions. And the district court erroneously concluded that the executive's actions likely violate separation of powers without making any finding that the agency's reduction in force is likely to violate any statute. And despite the president having constitutional power. Now, the Supreme Court, they say, you recently intervened in another maniac case to stop some other district judge from undoing the effects of the lawful large-scale termination of probationary government employees. Office of Personnel Management in another case. That was back in April. So you, Supreme Court, should do the same thing here, where this injunction is far more broad. It covers most of the federal government, and it even restricts Trump from planning personnel actions, okay? It's not only you can't fire them, it's you can't even plan to fire them. So just sit there and have these people work indefinitely. Now, as this court has recognized, Supreme Court, federal courts do not possess a roving commission. They can't exercise general legal oversight over the executive branch. And furthermore, it is within the president's authority to manage and run the executive branch. Now, in February, pursuant to his authority, President Trump came out. He issued an executive order directing the federal agencies to promptly undertake actions to initiate large-scale rifts. We were here for that, and it was delicious. The president's order rested on firm legal footing, followed a long historical tradition. In fact, for about 150 years, Congress has recognized the executive branch's authority to carry out reductions in force as the need arises. There are other statutory preferences for veteran status and other factors, and it's all in the law. There was a Supreme Court case about it called Hilton versus Sullivan. Look it up, 1948. The executive has repeatedly exercised RIF authority before. In fact, in 1993, Bill Clinton ordered all federal agencies with more than 100 employees to eliminate not less than 4% of their civilian personnel positions within 3 years. They did it, aiming for a government-wide reduction of about 100,000 federal workers, and no injunctions were issued then. Now, nearly 3 months after Trump issued his order, however, several labor unions, advocacy groups, and local governments, like the respondents, they all sued the president, almost every executive department and other federal defendants, and they took this where else? To the forum that they love, California. They sought to enjoin implementation of Trump's order and a follow-on memo jointly issued to everybody else, right? So they sent this planning memo from the OMB. Get ready. Start packing your bags. Everybody, your job tonight, your homework, bring in a cardboard box with you tomorrow. The district court quickly granted a universal injunction. Oh no. First, as a putative temporary restraining order, then as a preliminary injunction, stopped Trump from firing anybody, went up to the Ninth Circuit as we saw. Now, this court should now stay their injunction. Let us fire these people. There are multiple flaws here. To start, Supreme Court, they can't directly challenge the RIFs for at least 4 reasons. These are good ones. 1, RIFs are indisputably permitted by federal law. It's in the law. Take a look at Title V, U.S. Code 3502. Read it. 2, the executive order directs preparation of RIFs only as consistent with the applicable to the law. Okay, so the executive order is telling everybody to follow your own laws as they apply to your agencies. There was also an admonition that it said repeatedly, follow the law. So no one's doing anything that's outside of the ordinary course of a reduction in force. 3, many of the RIFs have not even been finalized. So they're suing over something that hasn't happened. We can't even plan. And 4, any challenges to the RIFs themselves have to go through a special administrative and judicial review scheme that is codified under other provisions of the law. We have the Civil Service Reform Act. If you're a civil servant, so-called, who's upset about being fired. And they're such good civil servants. Don't you understand this? They want to serve you so much, and they're so good that they're going to serve you whether you like it or not. And if you say, we've got too many of you and it's not really working out, it's not that efficient, and the whole country votes to get rid of them, they are such good civil servants that they will refuse to even leave. That's how heroic they are. So here, facing these obstacles to any direct challenge to the RIFs, respondents have instead manufactured an objection. They just make it up. They say they cannot end run all those obstacles, we say, merely by suing and bringing this up here, which is what they've done. Now, the general direction and guidance contained in our memo are unquestionably lawful. The entire executive branch belongs to the president and the president alone. Doesn't have to go consult with Hakeem Jeffries before he fires a bunch of bureaucrats who work in the executive branch. That includes the power to effectuate policy objectives by directing agencies to use their already statutory confirmed authority to conduct the RIFs. The district court turned the constitutional structure upside down, shifted the burden by treating as supposed evidence of unlawful action the mere prospect that agencies are acting at the direction of the president and his team. Just the prospect. It's wild. Now, equally meritless is the district court's objection that the president may not, without Congress, fundamentally reorganize the federal agencies. And that's what I guess they're saying Trump is doing without Congress. Now, what are you talking about, Judge? You're just making stuff up. It says the executive order makes clear that in proposing RIFs, agencies should ensure they do not eliminate any subcomponents that are statutorily required. It's in there. Or prevent the performance of functions that are mandated by statute or law. And the memo, and by the way, like Trump hasn't done anything because the judge stopped them from planning or firing or doing any of these things. So they're complaining about something that hasn't happened yet. The order says this is not going to happen, and they're upset about something that hasn't happened yet. Now, the memo reaffirms, look at the law and follow the law and the authorities that you've already got. The president does not need additional authorization to direct any of this. To conduct RIFs, all of this are within the bounds. Congress already explained what the rules are, and they're following it. Now here, the AFL-CIO and neither the court below, they all failed to show that a single agency's organic statute would be violated by any proposed RIF at all, much less that any such violation would actually be traceable back to the executive order, Trump, or the memo, rather than to the agency's hypothetical failure to follow the order's clear instructions to pursue the RIFs in compliance with the law. So, in other words, they haven't shown any actual problems yet. And they haven't shown them happening in actuality, right? That somebody broke the law, or that the organic statutes, if they don't break the law and follow the law, that somehow that path is going to be bad. So either way they go, nobody's actually dropped the ball because nobody's doing anything because they've been stopped and there's an active injunction right now. So they can't do anything. But if they could, and they follow the law as they're promising to do, and the other branch of government should be given the good faith and the benefit of the doubt in this, how are they going to violate the law by just following the organic statutes as they're already existing by Congress? They can't, right? So there is no actual evidence. It's all hypothetical. It's all speculative. So they're making it up, and they just then complain about something that's not even real. Now, exacerbating matters, the district court then joined a parade of other courts. They all entered universal improper injunctions, extending relief far beyond what was necessary. It also enjoined almost 24 executive agencies. Like it's a judicial takeover. It's a coup where they can just say, you're done. 24 executive agencies. Plus anyone acting under the president's authority from implementing any RIF pursuant to the executive orders, regardless of whether the determination at issue would have any effect on the respondents in the case. Okay, so even people who are not a party to the lawsuit are now being protected, just like the illegals, because they get class action protection too. Now, turning to the equities, the district court's flawed injunction, and the equities is this idea we're balancing the harms to each side, measuring the benefits to each side, and weighing them out against each other. Inflicts ongoing and severe harm. They say, we need you to intervene here, Supreme Court. What this lower level judge and the Ninth Circuit are doing are interfering with our internal operations and our unquestioned legal authority to plan and carry out these firings. And it does so on a government-wide scale. Basically, everybody is caught up in this. Now, more concretely, the injunction has brought to a halt numerous in-progress RIFs in more than a dozen agencies, sowing confusion about what RIF-related steps agencies may take and compelling the government to retain at taxpayer expense, right? All these people just sitting there, probably not doing anything useful because they were fired and then unfired, or probably know they're about to get fired, right? The probationary employees and all the people who are at the low end of the totem pole here are now in this limbo status. And the court says you can't make any changes. Everybody has to just keep collecting their paycheck. And of course, we're paying for that. Now, thousands of employees whose continuance in the federal service that they deem do not need to even be in there and are definitely not in the public interest. And so D. John Sauer submitting this, saying you need Supreme Court to stay the district court's injunction and allow us to do our job. The statutes and the law allow us to do it. As World War II concluded, it was widely understood the federal government would need to shrink dramatically as the nation shifted to peacetime footing. We had a bunch of laws passed, and Trump is building upon those. The executive order was just like Clinton's order, and it had a bunch of various exclusions for public safety and immigration enforcement and many other things. And we issued a memo, and it made direction to other agencies to follow the law, which of course they would do if we were allowed to move forward with this. We held a hearing back on May 9th, and the judge issued a TRO, an injunction, a restraining order the same day. Then we took this up to the Court of Appeals. Under the district court's order, everybody is limited, right? Everybody. OMB, OPM, U.S. DOJ Service, 19 agency defendants, all these people now limited on how they can manage their own agencies. On May 30th, the Ninth Circuit came back out. It was a 2-1 decision over there, and the judge dissented below. Judge Callahan explained that we are effectively challenging the prospective termination of the federal employees in the aggregate, but they are all precluded by the law, right? There's other statutory schemes that they could follow. If they're unhappy that they're a bureaucrat that got fired, there's many other avenues upon which they can go for back pay, for damages, whatever, but they can't stop the entire federal government from doing their jobs. Now, respondents' claims were not justiciable in the district court. They say, first of all, the court lacked jurisdiction. District courts have jurisdiction over civil actions that arise under the Constitution. But there are other statutes that have set up other avenues, like the Merit Systems Protection Boards and others. When you're in employment with the federal government, your claim, if it's a breach of employment claim, it goes over here. You don't file in the district courts, which is why we've created these frameworks. This framework precluded the lower level district court from even exercising jurisdiction. They need to go sue in the right forum. That's why we made it up. At bottom, this case is a dispute about employment relations in the federal sector, and they go over there. Even the district court admitted that. Numerous courts in recent months and years have applied the same preclusion principle to similar suits, citing a bunch of cases there. The district court's aberrant jurisdictional analysis was unsound. The judge said, well, I'm going to keep jurisdiction anyways, like we've seen in many other cases, because they find some constitutional component to their claim. They're like, well, it's not about employment. It's about the due process in the firing and losing of the employment. Or it's not about, I think we saw one where it was not about the contract that was canceled. It was about the decision to cancel the contract. That's what the suing was. What? That's resulted in the firing. No. We're stopping the decision. She doesn't have the power to make that decision. Okay. So finally, they write to the Supreme Court. The courts below noted that even if the union respondents and their members could seek relief, the other respondents, the nonprofits, the local governments could not. And so this case should not be here. Now, regardless of whether the lower court had jurisdiction, they lack alternative claims as well under the APA or ultra virus causes of actions. And their claims are meritless. The legal basis for the memo and the order that came out from Trump are lawful, all codified very clearly under the law. Consider the executive order. Now, in addition to the president's own statutory authority to oversee the civil service, he's got this little thing called, Article 2 of the Constitution. And all of the executive power, all of it, according to SELA law, is vested in a president. Now, the court has applied this principle before, specifically in the RIF context. In fact, in Nixon versus Fitzgerald, 1982, the court explained it clearly is within the president's authority to prescribe the manner in which people in the branch do the business. And our structure presumes that they will be subject to the president's superintendence. Our memo is the same. It's very similarly sound and follows all of these other regulations. You see these CFRs, Code of Federal Regulations here. Now, as for the Office of Management and Budget, there's also statutory provisions that allow them to do what they're doing. And a RIF is not a reorganization, okay? So don't try to reframe it as that. That generally refers to a restructuring. No one is saying to do that, but neither the respondents, unsurprisingly, or the lower courts showed that any of the ongoing or impending RIFs actually exceed statutory strictures, right? Where is the actual harm going to come from? Like, what law is being violated? You say he's violating Congress? How? What? How? Tell us how. They only offered a conclusory, speculative, and unripe allegation to that effect. They said like this. There is no possible way that the AmeriCorps employees can perform the work needed to run this agency in compliance with its statutory duties. That's their language, okay? There is no possible way. Wow. Okay. How many people are going to be fired? We need more than just that. Just a conclusory spec. And is that true? Like, there is no possible way? So Trump can't fire anybody as long as somebody comes in and that's the evidence. My business is going to be destroyed. Why? Well, there's no way I can do it. Okay, well, I guess that's right. I guess you're a government worker for the rest of our lives. So likewise, the district court said only that it was not convinced and had significant questions about this, and that's it. Now, saying that alone is enough evidence to call this whole thing unlawful is ridiculous. The courts below fared no better when they were analyzing large-scale rifts. They said even Bill Clinton nuked 100,000 people. They didn't scream about it then. The lower courts additionally faulted OMB and OPM by saying that they were using too much power. With very little analysis, the district court also concluded that they engaged in rulemaking and said they broke the law in other ways. So the injunction is overbroad. D. John Sauer tells us that the Supreme Court is likely going to grant this because it is going to harm the executive branch, not them. More concretely, the consequences here are stark. The injunction has disrupted and brought to a halt a complex government-wide effort, which began with President Trump's executive order more than 3 months ago to prepare for and to execute these RIFs. It stops more than 20 executive branch entities and any other individuals acting under their authority or the authority of the president from doing anything. All of this is delaying and disrupting our work. Now, the inevitable consequence is to compel federal agencies to keep large numbers of employees on the payroll without necessity. The Trump administration doesn't need them. If the union wants to go hire them or they can go work for a state government or somewhere else, that's fine. But they're not entitled to this at unrecoverable taxpayer expense, thereby frustrating the government's efforts to impose budgetary discipline and build a more efficient workplace. You can't have that. You have to pay them. These are their foot soldiers. They have to get this money coming in. Otherwise, the unions can't donate back to the Democrats. Saying here, This is costing a lot of money. The Congress appropriated the money doesn't mean that it should be wasted, does not mitigate the obvious injury from unnecessarily wasting appropriated funds, right? Which is great. They say, well, Congress said that you have to spend that money. That's fine. Don't have to spend it on these losers. They're all gone. We're firing all of them. And we'll hire, but we'll spend it. Don't worry about us. This is the government we're talking about. We'll spend that money. We're in the cutting phase right now. We will be bulking. Don't worry about that. But not with the same employees as the last guy. So they're gone. Just because it's appropriated doesn't mean we have to spend it on Democrats. Now, this court has expressed concern about the intrusion inflicted by this court order. They tried to say this was a problem when they tried to reinstate a single government employee. You remember that. Now, we have to reinstate every government employee? It follows that a universal injunction freezing a much broader layoff unquestionably inflicts substantial and irreparable injury on the government as the employer. And this injunction has sown confusion over the executive branch. Can we fire anybody? What's a riff? The caveat that agencies may engage in their own internal planning does not mitigate this problem. They say we can't even discuss these things. And it's inviting a lot of needs for clarification from the court. Now, their assertions of irreparable injury, they say, well, if the bureaucrats are fired, then we can't collect our dues. That is not enough to stop us from executing the law of the executive branch. The district court primarily rested its finding saying that unions and union members would be hurt. Now, that form of injury is by no means irreparable, right? They can just get more money because employees can seek reinstatement and back pay through the proper channels. Now, that this case implicates more than one individual employee doesn't mean that everybody gets the same remedy either. Like they can all, maybe they're fired for different reasons or whatever. Now, the district court also cross-referenced its finding with respect to other respondents and their standing, saying, wow, yeah, federal agencies may be delayed, local government tax bases may be reduced. And so if you're downstream, saying these are speculative, indirect, downstream harms, and that was sufficient for standing. They say, no, it's not. Irreparable injury is also not there either. And so those standards were not met. Now, if the employees who face rifts are not themselves entitled to relief as an equitable matter, it would turn equity on its head to grant them injunctive relief because there's a bunch of them. And for the foregoing reasons, you guys need to do something about this. So, Supreme Court, we're knocking on your door. You should stay this May 22nd order that was also affirmed by the Ninth Circuit. And we request an immediate administrative stay of this case from the Supreme Court to the Supreme Court of the United States. So Ninth Circuit is saying that the lower level stay was denied. They're asking for the Supreme Court to come in and grant them the stay. Let's see if we can pull this docket up right here and see if this, no, it's not going to give it to us. All right, so we'll keep our eye on this docket. This is the Supreme Court of the United States. Trump knocking on the door. We'll see what the Supreme Court says in response. I believe Judge Kagan issued a response and said that the AFL-CIO has until Friday or a week or so to respond. And so we'll keep our eye on that one. Now, let's turn our attention to this election case, because this is another interesting one. The Supreme Court decided to hear an election case, this one involving ballots that come in after Election Day. Very interesting issue. We thought that you kind of had an Election Day so that you could get all the votes in, count them, and declare a winner, and everybody would go home and know that we had safe and secure elections. But Democrats don't like that game because oftentimes there's a deficit there, and they need to close that gap, just like we saw back in 2020 when those charts went all like this. We all went to bed, and then we woke up, bloop, bloop, and the charts were all different after 2020. Well, now the Supreme Court is going to hear the challenge to an Illinois mail-in ballot law. New York Times has some background on this. Then we'll go into the actual filing that was submitted to the Supreme Court that they accepted, so we can get some background on what is coming up. But the New York Times gives us some background here, saying that they announced Monday that this lawsuit brought by conservative congressmen will be heard. And it's challenging an Illinois election law that allows mail-in ballots to be counted up to 14 days after an election. So 2 weeks, the election date is over, and they want to close the gap on that and do that F thing that we saw in the charts. And so they just go get them. Call all their absentee friends, whatever. It's like Arizona, I think, was like 14 days. Remember that? They made fun of us for still making fun of us. Rightfully so. And now they want to codify that so that no matter what happens, you can get your ballots in if you really need to. Get a few of them in too if you want. Representative Mike Bost is a Republican who represents a district in downstate Illinois, along with 2 federal electors. He sued back in 2022, saying you're violating federal law. You can't allow absentee ballots to be received and counted after the election. And all those absentee ballots, we know which way those go. Republicans have repeatedly challenged these, saying Trump lost in 2022 because mail-in balloting was expanded back during the pandemic. Remember all those ridiculous lawsuits we covered back then? A federal trial court had dismissed the case. They said no standing. Isn't that interesting? So if you're an illegal alien and you sue to challenge your deportation, judges will issue classes of illegal aliens, status, lawyers, due process rights, multiple hearings, all these things, like additional, like due process premium. They already had due process rights, but due process premium, where they get extra hearings, free lawyers, red carpets, all the things. But if you sue because your government is illegally breaking the federal law, no standing, go home, get out. We want illegal. Maybe that's part of the process. They want those illegals to vote as well. That's the process. So maybe absentee. Now, a federal appeals court agreed and said Mr. Bost, who's represented by Judicial Watch, shout out to Tom Fitton, asked the justices to weigh in. So the election law dispute is one of a bunch of cases the Supreme Court was considering. Here was the list of orders that came down. And you'll notice a bunch of cases got denied, but not this one. Boom. 24568, Michael Bost et al. Versus Illinois Board of Elections. And so the Supreme Court will be hearing this case. Here is what they sent in. And the question is a good one. Supreme Court, can you help us figure this out? You know, federal law sets the first Tuesday after the first Monday in November as the federal election day. It's in the U.S. Code. Several states, including Illinois, have enacted state laws that allow ballots to be received and counted after Election Day. Now, we contend that these state laws are preempted under the Elections and Electors Clause. Petitioners sued to stop Illinois from allowing ballots to be received up to 14 days after Election Day. Cheaters, man. The sole question presented here is whether petitioners as federal candidates have pleaded sufficient factual allegations to show standing. Can we at least be heard like an illegal alien in this court, please? We're like elected officials. Can you hear our case? Please. Can we challenge this, the time, place, and manner of the elections because they're breaking federal law? Supreme Court? We'll see what Amy Coney Barrett says. Of course, they accepted it, so we'll see what she says ultimately. But we got the parties to the proceedings. So we got these people. We got a U.S. congressman, right, called Michael J. Bost, and Republican presidential elector nominees suing Illinois State Board of Elections. And here is what they send into SCOTUS, which was accepted as of today. They sent this, writing, all right, Supreme Court, we're knocking on your door and trying to get your help on this because here's what's going on. For over 130 years, this court has heard claims brought by federal candidates challenging state time, place, or manner of elections. Now, until recently, it was axiomatic that candidates had standing to challenge these regulations. That I'm running in that election. This election is going to count votes for 2 weeks after the election is over. I have a problem with that because I think that I will lose or whatever. Now, indeed, it's hard to imagine anyone who has a more particularized injury, somebody who's actually involved in the candidate who's on the ballot, Now, that is because a candidate who pours money and sweat into the campaign, who spends time away from her job to do all of this, has an interest in the lawfulness of the election. And it's not just some random voter who is suing. And we have this other concept in standing, which we talk about, which is this idea of a political question. And the thesis on that is that you can't just sue your government because you're unhappy with the functioning of the government. If it's a political question, go vote, go run for office, go raise money. This is America, right? Go scream at your friends, go be like Tim Walz and bully somebody or whatever. Okay, don't do that. But the point is, get active. You don't just get to sue because you're unhappy with taxation or something, which, would not be a bad option. But the point is, we're not just random people. I'm a party to this. Now, in the aftermath of 2020, which we covered at length, we did dozens of lawsuits here. However, for a variety of reasons, courts have limited candidates' ability to challenge the electoral rules governing their campaigns. Yes, because it's rigged. Now, this case presents the latest and an extreme example of this trend. So they change the rules. Candidates sue. They say you can't sue. And the changes happen. And then who sues? No one. Voters sue, no standing. We saw all of this during 2020. Like 90% of our cases were kicked out on some stupid excuse of standing. Petitioners were saying, who can sue then? We saw electors sue. We saw candidates sue. We saw voters sue. We saw like party leaders sue, presidential electors sue, secretaries sue, states sue. No standing. So who can sue? Nobody, because the courts get to decide who wins elections based on these findings. Now, petitioners are a sitting multi-term congressman and 2 federal electors. They challenged an Illinois law, which is this receipt deadline law, that allows absentee ballots to be received and counted after the day specified in federal law, which is known as Election Day. Now, they contend that Illinois' receipt deadline is preempted by the federal Election Day statutes. They asserted Article 3 standing on a number of grounds, including that they incur costs to run their campaigns and more, and they claimed a particular interest. Now, a divided panel of the Seventh Circuit affirmed the lower level court's dismissal. They said, no, it's not enough standing. The majority said that the congressmen and the electors had not pleaded an injury in fact because in the court's opinion, they did not need to conduct post-election monitoring of late arriving ballots in 2022, and thus any expenses were self-inflicted. Okay, that's rich. So wait a minute. You guys didn't check the ballots after this law was already in place in 2022, and you didn't. You had to spend money, but you didn't have to. So what you're claiming is harm, like they filed, this is harmful. Like we did spend some money monitoring, and it cost us money, and so that's an actual concrete harm. Here you go. Here's evidence that this violation of the law is causing harm. Here's the harm. And they say, well, you didn't need to do that. There's no requirement for you to do that. You should have trusted the system. And so now, since you paid a bunch of money to monitor it, that's your problem. That's not harm. It doesn't count. So therefore, you have no standing. Seventh Circuit said that too. The court also declined to find standing because the 2024 election was back then 2 months away. So rich, man. So, and they did this too last time in 2020. No, the election hasn't happened yet. There's no fraud. Well, there's going to be fraud because they changed the law. Like they changed the election manual. The law says they have to do it this way, but they just published the manual for the election on how they're going to operate it. And it says it's illegal. Like it's illegal to the law. They said, well, you haven't seen that it's going to be illegal yet. The election hasn't happened. So no standing. This case is not ripe enough. It's got to ripen up. Then after it's over, you sue, they find another reason why there's no standing. Might be mootness. Now, well, it's already over now. And so now there's nothing we can do about it. And you should have raised that objection before the election like we did in like 50 lawsuits. But you didn't have standing for those. So it's a back and forth, right? It's a cat and mouse game, and whatever happens, they win. Now, until this ruling, because when you control the rule keeper, when you control the referee, you can win the game. Until this ruling, the only non-vacated circuit authorities to confront the question of candidate standing had held that candidates do have standing to contest violations of federal election law that actually impact their campaigns. And so we, the Congress people now, respectfully submit to the Supreme Court, which accepted this, that it is important for the court to correct the serious errors of this Seventh Circuit, especially those that are fostering an arbitrary approach to jurisdictional issues when federal candidates sue. It's also important that lower courts and potential litigants know, and the public know, that federal courts are open to hear timely, well-pleaded challenges to state time, place, and manner regulations on elections. Federal court rulings on the merits, regardless of the outcome, promote public confidence that federal elections are being conducted fairly, with integrity, and in accordance with the law. And that is such a key point on this. Rulings on the merits. You remember after 2020, they still talk about it like, we beat Trump in 120 courts or whatever that final number was. It's just made up number. Just forget it. Because none of them, almost, I think basically none of them were on the merits. Like which cases do we have like full trials on? We had a pretty good hearing in Arizona, but that was related to Kerry Lake. And I'm trying to think of the other cases. Most of them were dumped on standing or mootness or ripeness or just the wrong party or political question. It was nonsense. So we had no actual conclusion where we got to peer inside the guts on a lot of these things that happened in 2020. And if we would have, then we could have seen, oh yeah, it's interesting how certain counties like bellwether counties all had numbers that went against the margins of prior elections or went against the, you understand, there were like a 50 different anomalies that we covered a lot here. Antrim County, we covered, all of the signature concerns, right? About even if you don't look at the ballots that went across the scanners, they were just changing the rules on signature requirements before the election even started. So the signatures didn't have to match. Or there were some places, I think in Wisconsin, where you could just register to vote online. And because of COVID protocols, you didn't have to signature at all. It was just all bypassed in violation of the law. But you sue and there was nobody did anything about it. Anyways, so we're back. Now Congress is authorized, they say, under the Constitution to manage time, place, and elections. And we're in favor of separation of powers no matter which way you splice it. What happened back in 2020 was, yes, the legislature has the mechanism. They write the rules for the manuals, the regulations, and how the elections work. What happened was blue state secretaries went and colluded with the courts or liberal entities like the Retired Alliance of America or whatever those Mark Elias groups were called. And then they would sue. So Mark Elias would sue Chris Mays, for example, or Jenna Griswold, or one of these people in these positions. Back in particular, Latches. Thank you, NY, on that. Latches, remember all those? Anyways, all these lawsuits were happening, and Congress set the rules, but the executives and private parties were creating settlement agreements and coming to new terms that they would enter in with the courts, and the courts would use emergency powers and judicial equitable powers to say, we can't kill people, obviously. And so they'd find other provisions of the law to make these compromise agreements now become the law. And we suddenly saw election dates all delayed. We saw signature requirements waived. We saw a whole list of things that was just a disaster. And it was because they were usurping power away from the legislatures. Now, Congress exercised that power when it enacted election day statutes back in 1845. And in fact, in 2022, we added even new things. But prior to 2005, let's go to Illinois. The law required that absentee ballots must be postmarked the day preceding Election Day and received by state election officials on or before Election Day. Okay, that was the law. So then in 2005, the receipt deadline was amended, saying that ballots received after the polls close on Election Day, but before the close of the period for the counting of the provisional ballots can be counted. Okay, so provisionals, these get extended to the provisional deadline. These ballots need only be postmarked on or before the election day. If they bear no postmark, then they got to certify within a time frame. So then election officials are directed to validate. Now, reading all this together, It means they've got up to 14 days to count their ballots. Saying 14 days, right? So that's what the law says. So then in 2013, Illinois adopted a statewide vote by mail practice, which expanded the category of acceptable absentee ballots. So then the Congress people sued. Multi-term incumbent representing Illinois. This other person is a director, and their complaint sets forth 3 claims. Constitutional violations, saying the receipt deadline injures them as federal candidates, in violation of their First and 14th Amendment, infringing their right to vote, and third, it violates their federal statutory rights under the law. They sued in May 2022, long time ago. Bunch of motions. 2023, the motion to dismiss filed by Illinois, the government granted. So they win and the Congress people lose. Then they appealed, went up to the 7th Circuit, sharply divided, 2-1 majority, said, nope, you don't have any actual injuries, so you can't sue. They reached that conclusion. They said late arriving ballots in 2022 were unlikely to cause the congressman a defeat because he won so big. He's like, well, who cares if they were fraudulent? You won. So since you won, there's no harm. To reach this conclusion, the panel took judicial notice that 6 months after they filed suit, he won by a large margin. They say you won, so there's no injury. Ultimately, the panel concluded it was speculative at best that late arriving ballots would cause him to lose. So since the fraud didn't happen here to you, no harm. The panel did not describe how in pre-election lawsuits anyone can determine whether this is a case or not. Panel didn't address that, just said, well, there's no injury here, and we can't really tell you how to tell if there's going to be an injury in the future. So, but you can't sue now. That's what we can tell you. Well, when can I sue? Well, we don't know. We'll have to see it before we can tell you. The panel distinguished seemingly binding precedent that recognized their injury and said, well, those cases are different. But we do have injuries. And the panel held against them. Now, as we go up to the Supreme Court, they say, you guys got to hear this case now, SCOTUS. The lower level court, the 7th Circuit, it said Congress people don't even have standing to sue. They made their ruling notwithstanding undisputed testimony that they would expend resources and additional campaign expenses on those additional 14 days. Like the campaign's not over. You got to get out there and continue to campaign. But the ability to sue has been narrowed again. So now even a congressman can't sue before? This is a very recent trend. They say for over 130 years, this court has heard claims brought in by federal candidates challenging elections. Here's a bunch of them. You've got McPherson, Bush versus Gore, Bush versus Palm Beach City, New York State Board of Elections, a bunch of them. Now, the panel and the dissent, however, illustrate how lower courts have struggled with this new question of candidate standing. These cases involve truncated proceedings with expedited briefing, little opportunity for adversarial testing of evidence. It's rushed, it's high stakes, low information decisions. It's a disaster because there's deadlines coming up. They all have to make their decisions before the clock ticks out. Pleadings are passionate and urgent. Now, in consequence, as many a scholarly review of the period concluded, courts took a very strict view of standing. And unmeritorious challenges and a desire for orderly electoral processes may have resulted in courts too cavalierly dismissing legitimate claims of standing, confusing standing questions with merits questions or both. Yeah, they were not going to allow Bush versus Gore to happen again or something in 2020. Just not going to let it happen. All the judges, all the attorneys. And so this reached 3 circuit courts of appeals in 2020. The 7th and the 8th circuits both ruled that federal candidates do have standing. Final circuit to continue that question said did not have standing. This court never reviewed that case. And so we need you to do that now. Now, though vacated, that other case is still permeating the lower court rulings, but it's been misapplied. This court's decision in Lance has been misread in a number of cases following 2020. And so you guys need to fix this. Saying the court's guidance is needed to correct the unwarranted narrowing of our ability to sue. And Supreme Court, you got to hear this. If you don't allow us to sue, it's going to implicate and cause tangible injuries. And this alone allows you to intervene. There is much more than a broad interest here. We've got actual concerns about the upcoming elections. Now, the panel noted that this congressman's allegations that after he lost, the election, he was going to monitor the counting of the votes. And the court below said, well, that's not enough of a harm. And we say it is a real cost, right? In order to run an election, you actually have to be able to run an election. We got to dive into politics, Rasmussen, Cook Report, bunch of other things. And there's a bunch of practical issues too. And we can't sue when the election is months away because it's too speculative. But then if it is 2 months away, then it's too impractical. It's like, well, it's too far away. And then the election's coming up and it's too soon to sue. So that's what they're doing. We sued. We've been suing all over the place. We've sued many times, okay? We filed a lawsuit well before 2022 and 2024. Rather than instituting emergency or expedited procedures, we pursued their claims through a pre-election challenge. But if courts use that against us, saying, okay, we sued before, we're suing after, we can't sue anytime, this is a bad incentive. It means we have no standing at all. And so you got to allow us to challenge these things. We have. We're showing you we've suffered an injury. It's going to be imminent. It was caused by them, and you can redress this. This congressman was first elected to represent the House 12 years ago. And he has seen the changes. He said it's significantly more difficult to find volunteers to work after Election Day, and all the expenses are gone. It costs time and money, and it's out of compliance with the law. He also alleged competitive injuries based on a prospect that illegal votes could diminish the margin of victory. He said, this will lead to the public perception that my constituents have concerns about my job performance and more. And so the panel made a mistake when they denied this claim. They said that there was no legal basis for us having standing, but there is, as you can see. There's at least a basis, but they didn't want to hear it. So finally, the panel erred by ignoring you, Supreme Court. That case involved Senator Ted Cruz in a campaign finance regulation when he made personal loans to his campaign, whether he knowingly triggered it and more. But the decision below is creating a split. And so we need you to come in here and settle this for us. So do we have standing to sue? Yes or no? And I think the Supreme Court is going to lean back towards yes, right? If they were happy with the lower level ruling of the Seventh Circuit, they would have just denied cert and said, yeah, no standing here. But this case is the ideal vehicle, and they've been on this for a while. It arises out of a motion to dismiss. It's limited to this one particular issue. There's no lengthy factual record. We've got a bunch of different questions to come up here. And it's time to settle this. Signed and submitted by Judicial Watch, Robert D. Popper, Eric Lee, and T. Russell Nobill, counsel of record for Judicial Watch, sending that in to the United States Supreme Court. And of course, the Supreme Court has now granted that. And we're excited to see where this one goes because we followed dozens of lawsuits in 2020. And those lawsuits were all largely dismissed, denied because of these issues. No one could sue anywhere. And they claimed victory, but we never got to the merits. And now, hopefully, the Supreme Court gives us that opportunity by allowing these lawsuits to proceed. And both sides will be suing, but I'm fine with that. Democrats want to sue because they think they lost an election. Let's go ahead and peer into those Pandora's boxes over there. We want to see how all the elections are operated and see what's happening mechanically. Now, the Democrats are not suing generally for those issues, right? They're not suing to say, well, we think that there was some fraud or something. They're suing to change the rules. So we got to distinguish those two. They sue a blue attorney general, enter a settlement agreement, judges accept it. The whole election is changed because they rigged the code. That's not what we're looking forward to. We want to see what's happening in the guts of these elections where we have blue secretaries of state like Katie Hobbs, who suddenly then comes in and wins in Arizona when she can't hardly put together a sentence. All right, anyways, so we'll keep our eye on this one. Good news out of the Supreme Court. They are accepting this case. Bost versus Illinois Board of Elections. We'll keep our eye on it. Thank you for subscribing and joining as we do. All right, we got one more update, my friends. And then we'll hear from you on the day. Yeah, Ted Cruz has a podcast. I saw that. I didn't subscribe, though. Did you? You should subscribe. Okay, I'll subscribe. We'll subscribe. He's a senator. It's good. He ran for president one time. All right, my friend, we like Ted. All right, so let's get into this one because this was not good. But here we are. The Supreme Court punts on the Second Amendment. In this case, David Snope versus Anthony G. Brown, the Attorney General of Maryland, suing over the ban on a certain type of weapon that was imposed in Maryland. Now the Supreme Court had an opportunity to accept this case, resolve it, and they didn't. And we have some good dissents here. Now, what we're going to see, it was a pretty close decision on this. We have Kavanaugh, who's going to come out and kind of give us this waffly, like middle of the road thing. And then we're also going to see from Justice Clarence Thomas why this case should have been heard and heard now. Here is what we heard from the court. They wrote, now the petition for a writ of cert, which would have been filed by the people challenging the gun ban, right? There's a ban on the weapons. You want to get that ban eliminated. Supreme Court, can you get rid of that ban? They just said no. Now, Justice Alito and Gorsuch, they would have granted the petition. All right, so you got two over there. Clarence Thomas would have. Kavanaugh probably would have. Let's see what he says. Kavanaugh says, respecting the denial of cert, he says, all right, look. In the District of Columbia versus Heller case, which was that major Second Amendment case, this court ruled that the Second Amendment must be interpreted in light of constitutional text, history, and tradition. Looking back to how things were interpreted during that time, and if the regulations on weapons were customary and normal at the time, then we could apply those here today. Now, the court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens, because handguns are in common use by law-abiding citizens, and the court held that the D.C. ban on handguns violated the Second Amendment as well. Because they're in common use, the ban violated the Second Amendment. Now, the court's later Second Amendment decisions in Bruin and Rahimi did not disturb the historically based common use test with respect to the possession of particular weapons. But this case primarily concerns the Maryland ban on the AR-15, a semi-automatic rifle. Americans today possess an estimated 20 to 30 million AR-15s, which is good, but not good enough. We need to double those numbers and pump those numbers up. So if you were looking for an excuse to go get one, go get one. The AR-15s are legal in 41 out of 50 states if it's legal, meaning that the states such as Maryland that prohibit AR-15s are something of an outlier, unless you're in Maryland. Now, given that millions of Americans own AR-15s, hopefully a lot more soon, and that a significant majority of the states allow possession of those rifles, petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected under the Second Amendment. And if that's the case, if so, then the Fourth Circuit would have erred by holding that Maryland's ban on the AR-15 complies with the Second Amendment. If they are in common use, then just like Heller, handguns are in common use, so a ban on those, illegal. Same thing applies. Now, under this court's Second Amendment precedents, moreover, it can be analytically difficult to distinguish the AR-15 at issue from the handguns in Heller. Yeah, AR-15s are semi-automatic, right? But so too are most handguns. Semi-automatic handguns and rifles are distinct from automatic firearms like the M16 automatic rifle used by the military. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense. And for their part, criminals use both of them as well in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America, almost like handguns are worse. So in short, under this court's precedents, the Fourth Circuit's decision is questionable. Now, although the court today denies cert, a denial of cert does not mean that the court agrees with a lower court decision or that the issue is not worthy of review. The AR-15 issue, well, then why don't you just hear it then? The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals, giving us a bunch of the cases here. Opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Now, additional petitions will likely be before this court shortly, and in my view, this court should and presumably will address the AR-15 issue soon, in the next term or two. Okay. So, I guess he would have granted cert and heard the case, but doesn't really care about it right now. It's like, we'll hear it later, so just deal with it. Second Amendment people, you don't need an AR-15 in Maryland, okay? They're going to protect you there. Your government cares about you in Maryland. Yeah, all right. So here you go. We got another dissent from Justice Thomas. Clarence Thomas, dissenting, he says, court, the state of Maryland prohibits ownership of AR-15s, the most popular civilian rifle in America. Now, this petition presents the question whether this ban is consistent with the Second Amendment. The Fourth Circuit held that it is reasoning that AR-15s are not arms that are protected by the Second Amendment. Clarence Thomas says, I would grant cert to review this surprising conclusion. Clarence Thomas says, the Second Amendment guarantees the right of the people to keep and bear arms. When raising a Second Amendment challenge, an individual has the initial burden of showing that the Second Amendment's plain text covers his conduct. Now, once a challenger makes that showing, the Constitution presumptively protects his conduct. And the burden shifts back over to the government to demonstrate that its regulation is consistent with the historical tradition of firearm regulation. Now, if the government fails to make that showing, the restriction must be deemed unconstitutional. Now, it is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework, writes Clarence Thomas. He says, let's start here. First of all, AR-15s are clearly arms under the Second Amendment and the plain text. What are you talking about? It's not an arm. How can you say that? It says in DC versus Heller, we held that the term arms in this context covers this: all weapons of offense or armor of defense. That's what we said. Explaining that arms includes anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. That's what an arms is, and arms are, based on the prior context of history. Thus, the Second Amendment extends prima facie evidence to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Okay? If it's an arm that's something like used in offense, then it's automatically presumptively covered there. Then you got to show why it's not. If you can't, your law is unconstitutional. AR-15 and the weapons like that fall squarely into that category. Now, because AR-15s are arms, the burden then goes back to Maryland. Yeah, it's an arm, so it's covered by the Second Amendment. So now you have to show why banning them, AR-15s, is consistent with this historical tradition of firearm regulation. But Clarence Thomas says, I am not aware of any historical regulation that could serve as a proper analog to Maryland. Maryland invokes the historical tradition of prohibiting the carrying of dangerous and unusual weapons. And AR-15s, apparently, they say are both dangerous and unusual, is what they write. Wow, it's dangerous and unusual. Wow, very scary to them. And AR-15s appear to fit neatly in that category. Tens of millions of Americans actually own them, and the overwhelming majority of them do so for lawful purposes, including self-defense and target shooting. So a prohibition on an entire class of arms that is overwhelmingly chosen by the American society for lawful purposes is outside of the government power, and you cannot do that. Now, despite the foregoing, writes Clarence Thomas, the Fourth Circuit upheld Maryland's ban that AR-15s can be prohibited, saying they are not constitutionally protected arms. They are not arms. They said, well, at first blush, it may appear that AR-15s are arms. But the court said more is required. Because the Second Amendment must be interpreted against its historical and legal backdrop, whatever that means, the Fourth Circuit held that challengers also had to show the right to possess AR-15s fall within the historical scope of the right to keep and bear arms. What? The challengers could not make this showing in the court's view because the Second Amendment does not protect the right to own dangerous and unusual weapons, including AR-15s. What? They said that you could possess the weapon, you could keep and bear arms, but that does not, like the keep part doesn't mean ownership? Now, this reasoning is dubious at least twice over since Clarence Thomas. The Fourth Circuit placed too high a burden on the challengers to show that the Second Amendment presumptively protected their conduct, and in its determination that AR-15s are dangerous and unusual does not even withstand scrutiny. Thomas continues, he says, the Fourth Circuit erred by requiring the challengers who are contesting the law to prove that the Second Amendment protects their right to own AR-15s, right? So again, the burden shifted to them. Make them show that they're allowed to have the Second Amendment apply to them. It's not how that works. Or in the terms of our Second Amendment jurisprudence, that their conduct falls outside the historical exceptions to the right to keep and bear arms. Now, a challenger only needs to show that the plain text of the law covers him, and that's what they've done. Once the challengers show that, then the government gets the burden to show, actually, no, we do have a historical limit. They place the burden on the wrong party. Man, what a great full circle segue on this, right? The burden got shifted again to the wrong party, just like they tried to do in the Ninth Circuit, just like they tried to do with the elections. Now, our precedents make plain the error. In Bruin, we had little difficulty determining what the plain meaning of the Second Amendment is. We considered the historical limits on the right to bear arms to ask whether the state met its burden. Court did the same thing in Rahimi. Now, the Fourth Circuit based its opposite approach, its contrary approach, on an analogy to the Free Speech Clause. But that analogy explains its error. The court reasoned that the historical evidence is necessary to prevent an overbroad understanding of the Second Amendment, just like the Free Speech Clause excludes certain things like libel, incitement, true threats, and more. Now, as we explained, however, the government bears the burden of proving the constitutionality of the speech restrictions. That burden includes showing whether that conduct falls outside a category of protected speech by pointing to historical evidence about the First Amendment protections. They're like, yeah, it's the same thing. It's the same framework. Treating the Second Amendment like other constitutional provisions, we have similarly placed the burden on the government to show that a regulation of arms bearing conduct falls outside of the Second Amendment. Now, under the plain text of the Second Amendment, the challenger's only burden, the only thing that when you sue you have to do is show it was an arm. And here they are clearly. An AR-15 is an arm. And the Fourth Circuit separately erred in determining that AR-15 fall within the exception because they're dangerous and unusual. Weapons in common use today for self-defense are fully protected. The Fourth Circuit nevertheless eschewed any inquiry into the commonality of AR-15s. It just scares them. Just looking, the word and just the sight of it, it just scares them. It could be a BB gun. It just, they'd freak out. Instead, the court performed its own independent investigation of AR-15s. They did an investigation into its utility for self-defense. They examined their military origin, they examined their firepower, and they examined its muzzle velocity. These Judges, I'm sure they did. With the boom boom sticks that scare their pants off. Our Constitution allows the American people, not the government, to decide which weapons are useful for self-defense. We don't give a crap what your opinion is on muzzle velocity. California judges, or wherever this came from. Maryland, a constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. You can only have a gun if it's not of military origin, if its firepower is reasonable, and if its muzzle velocity is not too fast. Because we don't want it to go too fast and hit you. Says, in line with that principle, and with the tradition of prohibiting dangerous and unusual weapons, we have never relied on our own assessment on how useful an arm is for self-defense before we deemed it to be protected. Actually, what you're really going to want is some other ammunition that's directly for self-defense. And that's why you don't need more than 10 rounds. You can only need 8, but you can only have them if they have hydroshock ammos. Says in Heller, which they would ban too. In Heller, we found handguns protected because of that class of arms. Americans get to decide which one is unusual. Stun guns were not unusual. In Bruin, we again found handguns were protected because they're in common use. Now, in response to the Fourth Circuit and their objection to common use inquiry, they said it would lead to absurd consequences. They said you could have a constitutional right to own a bazooka, which we should. They said you could also have a ricin pellet firing umbrella gun, which also, I don't know if they had those back in the old days, but why not? Or even a W-54 nuclear warhead. Wow. And I guess we could have SEAL Team 6 probably also too, launch those nuclear warheads when Trump takes over power and becomes the dictator for life after January 6th again. A W-54 nuclear warhead. Well, I think I could be pretty responsible with one of those personally. I mean, I wouldn't launch it against anybody. Probably. What's up? So this reasoning illustrates why the scope of the right, these judges are ridiculous, obviously, right? Now, even if some nuclear warheads are small enough for an individual to carry, let's get into it. Okay, you want to talk about nuclear warheads? Weird judge? Clarence Thomas says, all right, fine. Yeah, let's do it. Even if some nuclear warheads are small enough for an individual to carry, no reasonable person would think to use one to defend himself. Putin might. Still less, or Putin might. Yeah, here. Still less could nuclear warheads ever become a common means of self-defense. There it is. Not common. To fend off the fantastical threat of so the judge is saying you're being ridiculous. So there's another standard that says common. Right? Most people don't have bazookas. Most people don't have ricin pellet firing guns. Most people are not going to have warheads. So according to the test that we've effected, common would solve your concerns. You're being hysterical. Common, it's not common to have bazooka. Not common to have rice pellet firing umbrella guns, although it looks cool. And a W-54 nuclear warhead's not common. But you are now trying to make a common thing, an AR-15, into an uncommon thing. So don't act like an AR-15 semi-automatic rifle is like a rice pellet firing umbrella nuclear warhead. Clarence Thomas rubbing their noses in it, rightfully so. To fend off the fantastical threat to of Americans lobbing nuclear warheads at one another. I don't know, man. I get pretty mad about that El Salvador case. I'll tell you what. The Fourth Circuit has allowed the very real threat of the government depriving Americans of the rifle that they most favor for protecting themselves and their families. Looking to the standards set by American society rather than our judicial colleagues, I cannot see how AR-15s fall outside of the Second Amendment's protection. And just to be clear, I wouldn't nuke, I would not launch a nuke. Although there is a pretty serious effort to, I think, nuke the moon, which could be interesting just to see what's going on over there. Anyways, here's what's happening. Says Clarence Thomas, I would not wait to decide whether the government can ban the most popular rifle in America. We don't need to wait Kavanaugh. We don't need to wait Amy Coney Barrett or Judge Roberts. Maybe that's what they're doing. The question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade. I'm getting tired of it. And further percolation on this is of little value, says Clarence, when lower courts in the jurisdictions that ban AR-15s appear bent on distorting the Second Amendment. I doubt we would sit idly by if lower courts were to subvert our precedents involving any other constitutional right. He's right about that. No, in fact, they flip out if you don't respond to an ACLU demand in 14 hours. Until we are vigilant in enforcing it, the right to bear arms will remain a second-class right. The constitutional status of AR-15s is all the more urgent after another decision in Bondi versus Vanderstock. Recently amended regulations of ATF provide that a firearm under the Gun Control Act includes objects that may be readily completed, assembled, restored, or otherwise converted to a working firearm. In Vanderstock, this court refused to hold that definition unlawful, reasoning that an artifact noun, that is, a word for a thing created by humans, may refer to unfinished objects, and thus that weapon parts kits are as regulable as the firearms they eventually may become. He says, but every single AR-15 can be converted to a machine gun using cheap, flimsy pieces of metal, including a coat hanger. So thus, on the court's logic, it seems that ATF could at any time declare AR-15s to be machine guns prohibited by federal law because you could just shove something in there. Now, until we resolve whether the Second Amendment forecloses that possibility, law-abiding AR-15 owners must rely on the goodwill of a federal agency to retain their means of self-defense. That is no constitutional guarantee at all. And so Clarence Thomas says, I respectfully dissent. Nice one from Clarence Thomas, man. And I didn't realize that this kind of issue has been percolating under their noses for 10 years. That makes Kavanaugh's sort of concurrence or dissent, whatever that was, as a mechanism of just allowing this to percolate even more ridiculous. So that's what SCOTUS did. The saving grace, obviously, is what Gun Owners of America flagged. It's Judge Kavanaugh saying additional petitions are going to come up soon and we'll handle it then. So maybe this is not the right case for them, but very nice dissent from Clarence Thomas. Second Amendment, second class right. And the Supreme Court they're busy right now, man. They've got too many deported illegal alien gangbangers to flip out about. All of them just waiting for the next ACLU class action lawsuit for Tren de Aragua and MS-13 to come in before they really get excited. But if you just want to enjoy the Second Amendment, well, in Maryland, not gonna happen, not anytime soon, because Supreme Court has more important things to worry about. All right, so my friends, what a beautiful day it has been and an amazing stream. I am appreciative of you joining us today. Quick recap for those of you who are just getting here. We got a update out of the Supreme Court on the firings cases. Trump wanted to get rid of a bunch of people with federal executive-wide rifts, reduction in forces. The Ninth Circuit Court of Appeals says you can't fire anybody because this is going to cause damage to them and they might have to move and the unions are going to lose a lot of money and it's going to cause death and chaos everywhere, whatever. So Trump submitted this to the Supreme Court of the United States. We read through the filing and it was a good one, submitted by D. John Sauer, and I believe Kagan has said a response is due in about 7 days. So we'll keep our eye on this, but as it stands, these employees will still be employed until SCOTUS decides and acts accordingly. So an update there. We also then saw there was a very nice new filing and lawsuit that was accepted by the Supreme Court on an election challenge in Chicago, Illinois, or Illinois, I think in general. They have up to 14 days for absentee ballots to come in after the election's over. So if a Democrat's down by 10,000, no problem. We'll just, get 10,001 absentee ballots coming in. Everything's gravy, following the law. So Congress people sued. Their case was dismissed multiple times by the lower level courts. They took this up to the Supreme Court of the United States, and today that case was granted. So not decided, but it will get scheduled for oral arguments and further briefing. And it should be interesting to see where that goes, because this was a critical issue in 2020. We couldn't sue anywhere because we had no standing. Everywhere we turned, nope, no standing. And there was no real repercussions for that rigged election that they rigged on the back of COVID. Then we talked about this bummer out of the Supreme Court. Supreme Court declining to hear a gun control challenge in this case called Snope versus Brown. Maryland ban on AR-15s because it makes them very scared up there. But they're, I think, perfectly okay with illegal aliens up there who are just, taking over half the country. But the point is, SCOTUS not going to hear it right now. Might be coming down in the future. Time will tell. And of course, we'll keep our eye on it. But my friends, thank you for joining us on this Monday. I hope your week is off to a great start. We appreciate you being here. Thanks for subscribing. Thanks for sharing our channel. And thanks for supporting our work with some great super chats. Welcome to our new membos. I see we got some membos being invited in. Very nice to see everybody. And what's up, Donuts clipping for us? We got membos coming in. What a beautiful day. You guys are amazing. Thanks for supporting our work here today. Here's what's coming in from today. Here is today. Now, from this morning. Oh, got it. Yes, from this morning. We got that one. Beautiful. Here we are. Your boy took a minute to get there. Monday, back to work day. Monday blues. What a real handsome, good-looking boy there just reading the news. You should watch the show. We'll read it for him. Hey, Milo Phone Bill. What's up, Milo Phone Bill? Still no charges filed against 32 arrested by Seattle police for vandalism at UW. One of the arrested is called Sam, a King County public defender and activist. No need to prosecute? Is this a behind-the-scenes plea deal? How is this possible? More of the same with Antifa attacks on a church group. And, man, I have no idea what's going on with this story, Milo Phone Bill. But vandalism in Seattle? Was it the neo-Nazis again? I'm sure. What's going on, former? I was a career employee, and I got riffed from 2 different jobs. 3,000 miles apart might be enlightening to look what happened to the Navy Department employees in 1965 and 1971. I wonder what authority was used back then. Milo says, if, for example, Boeing loses a government contract and has to pay thousands of employees, can their unions, IAM and SEPA, sue Boeing for unions' loss of income, not for employees? Is there case law here? I'm sure there is case law there. I would say no, right? I don't think you can sue the government for ending a contract, right? I would say just basically what we read in D. John Sauer's argument was no. Like if there's other mechanisms to file. You can sue. You can file claims for a loss of a contract if you feel like it was invalidly taken from you. Like there are mechanisms if you're a bureaucrat who sue, but you can't sue under a constitutional violation and then get a nationwide injunction that is spread across the entire country. So like there are claims, sure, yeah, just like you get fired from your job, sue, yeah, file, but you can't sue the government to stop your boss from firing anybody everywhere because you're mad they fired you or something like that. It's like, it's not like that at all. So I think the question is really about the forum and the mechanism of stopping the harm is inappropriate. Doan, what's up? Obama shrunk the federal workforce more than Reagan did, but not even close to Clinton's reductions with no universal injunctions, clearly targeting Trump. Yeah, and you would imagine that I would think like, Clinton was probably doing his purge to get rid of the Reagan people, right? So like the reduction in force was to get rid of 8 years of Reagan and Bush, by the way. Okay, so like 12 years of Reagan and Bush. So it's not like Al Gore and Bill Clinton didn't come in like, we want an efficient government. No, they needed excuses to get rid of all of the Republicans, which they did. Then they built up the entire bureaucracy in their image, and now we got to get rid of them. All right, that's just how this goes. So A.C. Barrett's collection of foreign adopted children appears to present inherent conflicting interests on the issue of illegal immigration. Yeah, that's an interesting question about that. Yeah, that's an interesting question about conflicts there. And I don't know, like, it's kind of uncouth, I think, to talk about kids, Supreme Court justices, stuff like that. But did her kids come? Is she involved in immigration? Did her kids come through immigration, adoption agencies? Like, is this an issue that's close to her heart? Is this why she's jumping out of her chair, screaming at district judges when there's not a fast enough response? NY, Rob, latches. You forgot about latches. Yeah, unclean hands and more. We remember that. Good to see you, NY. Steele Manning. The media was ready to call him a terrorist until they found out his name was Mohammed. Oh, yeah, from the attack. We talked about that this morning. They seem spring-loaded to go a number of different ways. Basically, whatever Trump and the administration was going to say, I think they were just going to say the opposite and say, how dare they say those things about this, whatever it was. Bruce Rice Baby. Thank you, Bruce. Look at this. We got 10 membos coming in. James German, PLM Productions, Jimmy Edwards. What's up, Crave? The Raz Rodriguez, Enohi Nova, Pineapple Water, Angelica, Kevin Murphy, Geezer Gun, gifted membos, courtesy of Bruce Rice Baby. Good to see you, Bruce Rice Baby. We got BillTongUSA.com is here. King of Biltong, shouting out his Biltong. And of course, there's the promo on your screen, courtesy of King of Biltong. What's up, Bruce Rice Baby? Bringing in 10 more membos in the house. Echo X Streaming. What's up, Ann Cool? Jeff Garageware Games. What's up, Beth Amphetamines is here. Marms is here. Bella Lynn. John O. The Warrior. We got Rascal Crimson. Danny Vardy. Gifted membos in the house, courtesy of Bruce Rice Baby. 10 more, Bruce. Benjamin Shirley. Alone the Wolf C. What's up, John TC? Ricky Grancy. Simmer Down, Texas. Cameron Strife. Tylene. Honey Badger. Mark Markin. And Clayton Tower. Gifted a membo, courtesy of Bruce Rice Baby. Thank you, Bruce, for bringing in a bunch of new membos. Grateful for you. And welcome new membos. We had a great members-only stream this morning. Check it out. Hey, Yvette. Thank you, Yvette, for being here for 3 months. Says thank you for all. Thank you, Yvette. Thanks for being here for 3 months. We appreciate you. 1/3 of the way to a baby. What's up? Doan is here. Says Second Amendment vultures want to stick us with the flintlocks. So how common use are those? Now they can file their complaints with feather pens on parchment paper. Yeah, that's funny too. Yeah. I'm sure you could play that game with them quite nicely. Like, I was just going to go down a pretty dark avenue. I was thinking about, well, what they're like, if the Second Amendment is a big issue for the right, what is their big issue? We're just not going to leave it. We're just going to leave it there. JPM and AZ. Any updates on the other case against Trump, the New York fraud case appeal? I think you're talking about the Letitia James case. No, not out of the New York Court of Appeals on Letitia James. No ruling from them yet. The other New York case is the Mercon case, which Trump is trying to remove to federal court right now. We did cover that last week. Fannie's case against Trump and others is basically dead at the moment. Fannie's disqualified. Case is dead. I haven't heard anything on that. I don't think it's been picked up by another prosecutor, so nothing there. I don't think it has a prosecutor. I don't think it has a prosecutor. So I don't think it's been dismissed officially. Has it been dismissed officially? I don't think so. I don't know. I don't know where it is at the moment, but the last I heard, she's disqualified. So I think the Fulton County is probably still trying to find the new prosecutor. I think they can't really make a decision on it. I don't think they can dismiss it. It's just not Fannie. So the case is kind of stalled out. So they got to go find the new prosecutor who's going to come on the case. Is it going to Cobb? Is it going to Cobb County? I haven't heard anything officially about it going to another county. Has another prosecutor picked it up? The thesis was if it goes to another prosecutor, they're going to want to dismiss that case. Like, what prosecutor is going to take it? Keeping an eye on anybody know more than I do on this one? I think it's pretty stalled out. I keep my eye on the all Fannie business, but I haven't seen anything on that. Anyways, there's so many cases it would be hard to keep track. Well, I think we're on all of them. We're waiting for the appeal for Tish. Mercon's getting removed. We know Florida's gone. J6 case is dismissed. Georgia case, I think, is just stalled at the moment. So I think that's kind of the only one we've got questions on. E. Jean Carroll stuff. Yeah, it's a good list. Thank you, JPP, for asking. What's up, Doan? Most firearm restrictions are unconstitutional. Yeah, and I think so should W45 warheads too. Rub some dirt on it. Hey, Rob, if you're sitting in your Abrams tank, does that make it something you wear for defense? Yeah, I think so. Yeah, I think so. As an aside, does that mean you're sitting in your closet if you're sitting in an Abrams tank? I don't know. But rub some dirt on it. Great to see you. So I think we're going to do an unboxing. I got to see what Heavy Johnny says about it. But Heavy Johnny, our friend in Japan, sent us over some top secret bootleg Chinese contraband that he sent over that we're going to use. I don't know if we violated any export controls or anything like that. Don't think so. But he sent it over. So I think we can do an unboxing on that maybe tomorrow on the members only stream. We got a good fun, a little fun device got sent over. We'll take a look at it. Rub some dirt on it is Whirlpool Galaxy and Galaxy Thor, aka Heavy Johnny. What's going on? Bill Dozer. I want a personal use nuke. It's my emotional support nuke. I won't use it for evil. I just want it for the flex so I can get the super official emotional support vest. You can carry it around in like one of those little baby carriers. What do they call it? Baby carriage? Baby cart? It's a baby cart, like a shopping cart. What do they call it? Stroller. Put it in a stroller with your dog next to it who starts to glow a little bit. Just put your little stroller. Oh, just taking the dog and the nuke out for a walk today. Or put it like in a baby carrier like here with a little nuke doing the show with you. Oh, that's fun. All right, so Bill, yeah, it's a little emotional support nuke. It's mutually assured destruction. I'm not going to use it unless you use it. You're not going to use it, are you? No. Well, there you go. What's the problem? No problem at all. Don't use it. Don't use it because I'll use mine. It's the same thing. What's the problem? Hey, King of Biltong. You sent me some Biltong, King of Biltong? Man, that's so amazing to you. Thank you, King of Biltong. I can't wait to try it. I have tried it. I can't wait to eat some more of it. Thank you, King of Biltong. Hey, Jim 63. Only 10% of watchers have clicked the like button. That just breaks my heart. Because they hate me, Jim? Is that why? Hey, Devilishly Angelic. Gifted membos over on Rumble. Wow. You can gift membos on Rumble now? This is incredible. Look at Rumble coming along. Cheryl's, Sanglant. We got Donnie Potwin. What's up, BCM? We got this one from Snoopy. All gifted membos. Thank you for doing that. Devilishly Angelic in the house. Thank you for gifting membos over there. Hey, rub some dirt on it. It says your Abrams would end up in the closet on the treadmill. Yeah. Next to my jujitsu gi, my gardening tools, my ham radio books and supply, and my telescope. Yeah. Well, I think I'd put all that stuff in the Abrams, because then I could just take it with me everywhere I go. I'll put the telescope on top of the Abrams. That makes a lot more sense. And we'll get some good scenery out there too, because we can take that tank up like to the top of mountains, like Lowell Observatory, whatever. Just barrel through. I like it. Rub some dirt on it. Yankee Free. Hey, thank you for the raid this past Friday night. Appreciate you. Hey, Yankee Free. Glad that happened. I'm glad you had a good stream over there. Shout out to our mods, Neuro D, and our Rumble friends who are sending us out. Yankee Free. Glad to meet you. Thanks for stopping by and for saying what's up. Hopefully had an amazing stream over there and got some new friends out of it. We'll see you back, no doubt about it. Thanks for sending them over there. Thanks for stopping by and saying what's up too. Yankee Free on Rumble. Make sure you're checking them out. Links dropped courtesy of Donut. Donut, thank you for doing that. Donut is link on the spot, man. Links on the spot. We appreciate that. Okay, so my friends, thank you for sending those in. Welcome, new membos. Thanks for supporting the work and the show and everything we're doing here. Thanks for connecting with each other in the chat. What's going on? We got some friends over on X. Danny McWilliams says, and people wonder why I switched to black powder and a crossbow. On the plus side, my 50 cal black powder can stop a car. Danny McWilliams. Good to see you, Danny. Hey, Gen X, cameras and good audio in every courtroom and broadcast at American buildings. 1A to hear America's business. Transcripts are not the full picture. Tone, facial expressions, time, thought, delays. Yeah, I think especially for court cases. maybe not for every here. Like, look, like I'd compromise. I'd be happy to compromise, but we want some access. I think we should be able to see inside federal courts and we saw this on full display last time. They didn't want us to see anything. Judge Chutkin didn't want us to see a thing. Merchan, nothing. Angeron, Areola, the Nip, nothing. Remember that? They wanted to keep everything as buried as can be. Hey, Snooch. Snooch. What a nice comment. Rob, you're a force to be reckoned with. Thank you for all you do. I could use a reckoning. That is for sure. Yeah, I know. Some people have told me that. You have a reckoning coming. You know that, right? Probably. I don't know what, though. We'll see. Thank you for that, Snooch. I know what you meant. I appreciate that. Thank you for being here. Thank you for sending that in and for being amazing. Well, hey, G-Man says the W-54 nuclear bomb was designed for special forces to parachute in behind enemy lines with it in between their legs. It weighs about 150 pounds. Nice. Yeah, you could definitely carry that in. Put that in a stroller. Just walk it around your neighborhood. Everybody can take their nukes out for an evening stroll. Yours looks good. Yours looks good too. Glad to see it's still operational. Yeah, you too. Yeah. All right, so G-Men. Hey, nuclear weapon bans are against the Second Amendment as well. Don't like it? Well, pass an amendment then. We have to follow the Constitution. It's true. All right. Well, we'll have to add another one then. Didn't Back to the Future already have this solved, by the way? What was the thing? What was Mr. Fusion in the back of the what's it called? The vehicle. 88 miles per hour. Flux capacitor. You know the car. Anyways, that car. He had the Mr. Fusion in there. He was driving around, putting a banana peel, beer, no problem at all. Like, that's what I'm expecting. We're all going to have it. All right. So anyways, my friends, thank you for sending these in. Thank you for sending these great donos in. Thanks for becoming membos. Thanks for liking the video and for sticking around. Membos, we're going to do an after party today. So if you're a YouTube membo, go back to the channel homepage, hit refresh in about 2 minutes, 5 minutes, and you'll see us on the membo stream. Locals, don't go. The DeLorean! The DeLorean. Thank you. Boopsie. Boopsie, Mad Hatter, Chetty Mo, the DeLorean. The DeLorean. Yeah, with the flux capacitor. Once this hits 88 miles per hour, you're going to see some serious stuff. All right, so good stuff. All right, so my friends, we're going to leave it there. Membos, stick around. I want to thank our amazing mods and meme smiths. We got Geegum, Donut. We got K-Bean, Carrie B, John's always helping out. We got our friends Neuro D, Janek, Dog Digger, Mod the Fort Down over on Rumble, Just Rhonda, Elliot, Docmaster. Elliot was dropping some serious docs, I think, this morning. Thank you, Elliot, for doing that. My friends, it has been a beautiful stream, a lovely Monday. I hope that your week is off to a great start. Doan says, bring up firearms and the talk time triples. And the talk time triples. Is that right? Well, it is an important issue. Yeah, that the Supreme Court apparently doesn't care that much about. So, all right, my friends, what a beautiful day it has been. We will leave it there on the day, but we are coming back tomorrow, and I can't wait to get into it again. And in order to do that appropriately, 1.21 gigawatts! Great Scott! We are going to come back tomorrow to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers, shining the light. Watching the watchers, defending what's right. Watching the watchers, still